Batlotlegi, ke dumedisa gape le Botswana ko gae. Mr. Speaker, I have the honor to present to this Honorable House for its consideration the Constitution Amendment Bill 2025, Bill number 14 of 2025. This bill was tabled for first reading in this Assembly on the 4th of August 2025. As you know, Section 88(2)(1) of the Constitution of the Republic of Botswana provides that the National Assembly shall not proceed upon any bill that, in the opinion of the person presiding, would, if enacted, alter any of the provisions of the Constitution, unless a copy of the bill has been referred to Nkiyadikhosi, after it has been so introduced in the National Assembly. The Constitution Amendment Bill 2025 was read for the first time and referred to Nkiyadikhosi as required by the Constitution, Mr. Speaker. Nkiyadikhosi convened from the 6th until the 10th of October 2025, and as part of that meeting also considered the Constitution Amendment Bill 2025. As required in terms of Section 85(1) of the Constitution, Nkiyadikhosi submitted its resolutions to the National Assembly. We will consider the resolutions in due time as per the standing orders. The main objective of the Constitution Amendment Bill 2025 is the establishment of the Constitutional Court. The Constitutional Court, Mr. Speaker, will form part of the judicial system as the highest court in Botswana. The courts are provided for under Chapter 6 of the Constitution, and we have therefore amended it to provide for the establishment of the Constitutional Court. I want to take this opportunity to share with the National Assembly that Chapter 6 of the Constitution is specially entrenched as it falls under Section 89(3)(b) of the Constitution. Section 89(3)(b) of the Constitution spells out the specially entrenched provisions of the Constitution. It provides that a bill for an Act of Parliament amending specially entrenched sections shall not be passed by the National Assembly unless the final voting on the bill in the Assembly takes place not less than 3 months after the previous voting thereon in the Assembly, and as such final voting of the bill is supported by the votes of not less than 2/3 of all the members of the Assembly. Mr. Speaker, allow me to go through the contents of the bill clause by clause. Clause number 1 deals with the short title and commencement of the bill. Clause 2 of the bill amends Section 8. Section 8 provides for the protection of people from deprivation of property where there is any compulsory acquisition of property. The Constitutional Court will now be the competent court for any contest against such transactions. Clause 3 amends Section 18 so that the Constitutional Court, instead of the High Court, is now the competent court to determine challenges on the fundamental human rights protected under Section 3 to 16 of the Constitution. Clause number 4 amends Section 69 so that the determination of questions of the validity of the elections of members of the National Assembly or the Speaker of the National Assembly is a matter for the Constitutional Court. Clause number 5 amends Section 75 so that the action for recovering from any person who sits and votes in the National Assembly knowing or with reasonable knowledge that it is wrong now lies with the Constitutional Court. Mr. Speaker, Clause number 6 inserts introductory sections under Chapter 6 of the Judicature to set out clearly the judicial authority of the courts of Botswana, the appointment and position of the Chief Justice as the head of the judiciary and conferring him or her with the relevant powers for that role, and to establish the new position of the Deputy Chief Justice. It also establishes the ranking of the Constitutional Court of Botswana. Clause number 7 amends Section 95(1) and 4 to limit the jurisdiction of the High Court so that it may handle only matters it is prescribed to handle, and so that in addition to determining places where the High Court may sit, the Chief Justice is also charged with establishing the divisions of the High Court as he or she may determine necessary. Clause number 8 amends Section 96 now to empower the Chief Justice to appoint judge presidents to head divisions of the High Court. Clauses number 9 and 10 amend Sections 99 and 100 to remove the Chief Justice as part of the panel of the Court of Appeal. Clause number 11 introduces a new Section 102A and other clauses that set up the Constitutional Court, its composition and jurisdiction, qualifications and the tenure of judges of the Constitutional Court, as well as the oaths the judges ought to take. Mr. Speaker, clause number 12 amends Section 103(1) to expand the membership of the Judicial Services Commission. A retired judge will substitute the Chief Justice as chairman of the Judicial Services Commission. The Chief Justice will remain a member of the Judicial Service Commission. This is to enhance transparency and independence of the Judicial Service Commission. The Deputy Chief Justice will also be a member of the Judicial Service Commission. Clause number 13 amends Section 104 to provide for the office of the Registrar of the Constitutional Court. And clause number 14 amends Section 105 to charge the Constitutional Court with the sole mandate to deal with the interpretation of any questions of the law as to the Constitution, and such decisions shall suffice to dispose of cases where such questions arise. Clause number 15 amends Section 106 of the Constitution so that appeals lie as of right to the Constitutional Court from any decisions of any other court that involve the interpretation of the Constitution. Clause number 16 to 19 amends Section 110, 116, 122, and 127 to include a judge of the Constitutional Court, where judges of the Court of Appeal and the High Court are included in those sections. Clause number 20 provides transitional arrangements to allow courts that are seized with cases to continue handling them to finality, notwithstanding that this Act takes away their jurisdiction. I thank you, Mr. Speaker.